Morning, Che.
How are you?
Fine, thanks yourself, Che.
Good.
Uh,
At least today there's no load shedding.
yeah, no. No, I
Yeah,
today got a reprieve.
yeah.
Hey.
I'll be able to run with our work.
Yeah, no, because the past those 2 weeks, it was tough.
Yeah, that's tough, yes.
Yeah.
But I think let's ensure that today and next week we push our things because this changes in the program also has an impact on our work.
Yes, 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 yes. We can plan, but there's no way
Yeah,
that you stick to the plan.
exactly.
Mm. But
Exactly.
at least next week, then it will be our last meeting. Then it's just
Yes.
recess. Then yeah.
Yes, yes, yes.
Mm.
Is it? I see the program of the Ziggy. Is it virtual or physical?
It's hybrid.
It's hybrid.
It's
Okay.
hybrid. Yes.
Oh, okay.
So
That's fine.
it's physical, virtual.
Virtual. Okay.
No, it's
All right.
physical, but it's hybrid.
It's hybrid. Okay.
Yes.
That's okay. Then I think let's then leave it as it is, so
Mm.
that I'm just worried about members that are not well, that the physical might not affect it.
Oh.
Yes, but we can work on that.
No, okay, no, it's fine. We can take this out of this meeting.
Yes,
Yeah.
all right. Yeah, good.
Okay.
Recording in progress.
Are we ready, Kibega?
Chairperson, we are ready.
Okay. Good morning, members, our guest from the department, and also the parliamentary monitoring group, and also the media at large. Allow me to formally open this meeting by welcoming all of you to this meeting. As you all remember, today's meeting is the culmination of the process that started after we received the bill, after it was referred to us to the national chair by the speaker. The last two engagements are quite important in terms of moving forward. We received the presentation from the department, particularly in relation to the response upon inviting members of the public to make presentation to the meeting that was held in June, and then in September we then invited the department. I think it was the 6th of September we invited the department to give us a response to that. But as we all remember that because of time, there are a number of issues that we could not exhaust, and therefore we then agreed to convene today's meeting. And having welcomed all of you, including also the support team to the committee. The agenda before us, as you can all see, it's marked the response by the Department of Transport to the written submissions and oral submissions. We have the department. I think what we are going to have, we'll have the members responding. Let's just juggle around the program. Committee secretary, let's have members engaging on clarity-seeking questions in relation to the responses that was made by the department on the economic regulation of transport. I think that's where we ended last time. We closed at the time when the department had finished making a presentation on their responses. So we then agreed that let's allow members to engage, and then we'll then allow the department to respond, and then thereafter we'll then move to the department's responses on the National Road Traffic Amendment Bill, and then have members deliberating in questions. Then lastly, then we'll have transport responding to the National Land Transport Amendment Bill. Let's move in that fashion. And then without any waste of time, let's check from the members if there are any engagements that they would want to raise in relation to the presentation by the department on the responses to the submissions that were made on the economic regulation of transport bill. I've noted Honorable Prateser. Team, the floor is yours.
Thank you, Chairperson. Chairperson, my question is of a general nature, and it comes down to the simple fact of the matter is that the economic regulation of transport bill is going to take away the ability of municipalities, of provinces, to regulate their own affairs in terms of tariffs, in terms of licensing, etc., etc., etc. And so the simple question is, how can the department justify taking away this authority and placing it in the hands of a regulator who can make arbitrary decisions from a central position that may not suit the local environment? Our constitution clearly says that the different spheres of government must cooperate with each other, but that one cannot tell the other what to do. And so that is the central crux around the problem with the bill, is this heavy-handed ability of a regulator to now decide to tell other spheres of government how they must manage their own affairs. So if we could just get I know this is a very general question, but if we could just get a general response to that objection, because that is one of the major concerns about the bill. Thank you.
Thank you, Honorable Prateser. Honorable Boshoff?
Chairperson?
Yeah. Yes.
I wanted, before we proceed,
Yes.
we had a request from the legal advisor, the parliamentary legal advisor on this bill. She's busy with the other committee, so she requested, to join this meeting in the afternoon. Hence, this were put in the afternoon. I'm not sure whether can we proceed without the availability of the parliamentary legal advisor on the ERT bill.
On the ERT bill, okay.
Yes.
Oh, all right. Now I now understand why you chuckled around the agenda. I hope members will be receptive to that, because I believe it will be in the interest of ourselves to get the benefit of the input from the legal advisor.
Before we carry on, Chair, I'm covered by Honourable Prateser. Thank you.
Thank you, Honourable Boshoff. Let's then defer this the responses. I hope it will also not create a challenge to those that were supposed to respond from the department. Let's then agree that we then proceed with the agenda as it was tabled. Then invite the Department of Transport to give us the responses to submissions that were made on the National Road Traffic Amendment Bill. Who will be leading that aspect, Committee Secretary?
I was given the name of Mr. Advocate Makgato. I don't know whether it's in or whoever who's representing Advocate Makgato.
Let's hear from Motsatsing.
Good morning, Chair, honorable members. Yes, in terms of the arrangement, Advocate Makatu was supposed to do the responses on the questions raised. However, he is currently at the Scopa today, and therefore he requested me to proceed with furnishing the committee with the necessary responses, Chairperson.
Thank you, Mr. Motsatsing. You can do that. Just show your face, and then you can proceed in terms of the presentation.
No, thanks, Chair. But I'll then request that because of the bandwidth, block my video once I've then showed my face. I'm not sure now. Can members see? I've opened the video, but it doesn't seem to show now.
Yes, then you can proceed, Mr. Motsatsing.
Chairperson, I'm not sure whether the committee secretariat will be able to flight the presentation that we forwarded. Alternatively, if I can then be given rights to flight the presentation.
Mr. Motsatsing, the rights has been granted. You can flight on your site.
Chairperson, honorable members, is the presentation visible?
Yes, it is visible, Mr. Motsatsing. You can proceed.
No, thank you, Honorable Chair, honorable members, and for the opportunity for the department to respond on the submission made by SALGA and Western Cape. And in terms of the responses, obviously, we looked at what was suggested by the submission made by SALGA and Western Cape, to the extent that in some of the suggestions we noted and we agreed with the proposed correction or amendment or inputs as suggested. And where we did not agree, we obviously then provided some form of explanation or motivation as to why we wouldn't want to accede to the proposal as suggested. Chairperson, I'm on slide 1, which talks to the comments that were submitted, wherein the Western Cape government welcomes the opportunity to comment and notes in particular the deletion of clause regarding the zero alcohol limit. In terms of the comments from SALGA, there were no suggestions made in this respect, Chairperson. And we note that in terms of the responses, they agree with the approach of which was taken by the portfolio committee to revert back to the current dispensation in terms of alcohol contents. Chairperson, if I go to slide 3 of the presentation, the suggestions that was made was to provide clarity on whether a power assistant pedal cycle, except for power assistant pedal cycle contemplated in paragraph 3, will be required to register and license, and therefore which category the above mentioned vehicle will resort for the payment of licensing fee. In terms of the DOT or Department of Transport responses, Chair, was that it is not the intention of the legislature to require pedal cycles to be licensed. And obviously, in that context, there would not be any necessity or need for the operator of that particular pedal cycle then to acquire a pedal cycle driving license, Chair. So In us submitting the response, Chair, we just want to express that there's no need for the pedal cycles to be registered and licensed, Chairperson. If I move to page 4 of the slide, the suggestions in terms of the numbering for the addition of the reserve traffic wardens should be corrected from 4 to 7 as follows: notice officer and reserve traffic wardens. We note the suggestions that have been made, and we are also then in agreement that the changes therefore can be made onto the proposed bill, Chairperson. Chair, if I moved to slide 5, the suggestion is that it is suggested that the wording of section 3, capital C, 2A be broadened to include persons known or connected with the examiner of vehicles as follows: an examiner of vehicles, if he or she, through any other person known to her or connected with her, has or acquires a direct or indirect financial interest in the manufacturing, selling, rebuilding and repairing or modifying of motor vehicles, or a corresponding amendment should be made to section 3(2)(b) of the Act. So we note the suggestions that have been made. However, what we are saying as the Department of Transport is that it would be a far-reaching requirements to the extent that how far would one then limit persons known to the examiner of motor vehicles? Because what we had attempted to do as Department of Transport is restrict the application of that particular requirements to close family members related to an examiner of driving license or motor vehicles, Chairperson and honorable members. But if we were to extend the requirements to person known, we are of the view that that would be far-reaching, because to the extent that at what point would we then deem that a person is known to an examiner of vehicles, and whether knowing a particular person has a bearing on the functions or that particular examiner has to perform, Chairperson. So we are of the view that the proposal would have a far-reaching unintended consequences in terms of the that particular provisions, and we will not be able then to enforce or regulate that particular aspect, Chairperson. If I move to slide 6, it obviously relates to that particular provision, Chair. It's just a continuation of what the proposal was suggesting. If I move to slide 7, Chairperson and honorable members, it is suggested that the wording of section 3, capital C, be broadened to include person known to connected to traffic officers and traffic wardens or notice officers as follows. And I think, Chair, it's the same kind of an explanation that we have furnished with regards to examiner of motor vehicles, in the context that if you look at traffic officers, traffic wardens, and notice officers, obviously the limitation in terms of their immediate family members would be appropriate to a certain extent. But if we were then to extend that particular requirement as proposed to person knowns, it becomes challenging to the extent that how then or how far do you restrict persons that are known to the authorities or to the examiner or traffic wardens, Chairperson. So it is the same response that we're furnishing to the preceding one, wherein we were saying the proposed insertion or amendment would have a far-reaching unintended consequences, Chairperson. If I then step off that particular slide and move to slide 8, which is obviously the explanation that follows from the above responses, Chairperson. There's no response on slide 8. If we move to slide 9, wherein the suggestion is that since there is a formal qualification for a traffic officer and not for other categories of officers or wardens, it is proposed that the following wording be inserted after the word qualification. Qualification to read as follows: an appropriate qualification or completed appropriate training at a training center approved by the shareholders committee. In terms of the suggestion, Chairperson, we note and we agree with the proposed suggestions in terms of the comments that were submitted, Chairperson. Chair, if I then have to step off from slide 9 and go to slide 10, wherein the suggestion is that it is suggested that the rationale for limiting offenses to those included in Schedule 1 and 2 of the Criminal Procedure Act be specified in the memorandum of the bill to inform members of the public as to the specific factors that were taken into account in exclusively designating Schedule 1 or 2 as the only schedules to be considered when determining a possible suspension or cancellation of registration of an examiner of driving license. The suggestion to include other serious offenses such as Schedule 5 and 6 are noted and welcome. The rationale to include this kind of crimes as listed in 1 and 2 of the Criminal Procedure Act indeed is to target the crimes that are of a violent nature, considering that the fact that the government officers are first point of contact and they interact generally with the road users on public roads, and it will not be ideal to expose members of the public to officers who may have potentially of being charged with a crime of a violent nature. Therefore, we were then saying that in terms of us specifying Schedule 1 and 2, our intention was to restrict those ones to where the offenses are of violent nature, Chairperson. But in terms of the extending that particular provisions, in terms of also including Schedule 5 and 6, we can then obviously give considerations to that proposal, Chair, but we were wanting to just restrict that particular requirements to Schedule 1 and 2 of the Criminal Procedure Act, Chairperson. Chair, if I then step from slide 10 and move to slide 11, and the suggestion therefore is to say that consideration be given to including other serious offenses such as Schedule 5 and 6 expressly in the formulation of Clause 6E. If the above consideration is taken into account, the memorandum of the object must detail the rationale behind the inclusion or the designation of the relevant schedules in this particular clause. As I indicated in my previous submission, Chair, it is noted and agreed if ever the approach therefore is then to include Schedule 5 and 6 in the those restrictions, Chair, and obviously there would be that consequential amendment that would have to be made on the memorandum on the object of the bill, Chairperson. Chair, if I step off the slide 11 and move to slide 12, the same comment applies with the insertion of 28B, capital B and 1 capital A in clause 30, which is noted and agreed with regards to if the rationale or the approach therefore is to include Schedule 5 and 6. Those consequential amendments would then have to be effected on all the provisions that refer to Schedule 1 and 2 of the Criminal Procedure Act to also then include Schedule 5 and 6 of the Criminal Procedure Act, Chairperson and honorable members. Chair, if I then step off from slide 12 and go to slide 13, where the suggestions would then was saying that delete the word may in the closing paragraph as follows: may impound, and it should read impound the vehicle. And we as Department of Transport, we are then saying the suggestion is noted and accepted, Chairperson. If I step off, it's just the follow on to that preceding section clause, Chairperson, and there's no response submitted in terms of slide 14. If I go to slide 15, Chairperson, the suggestion is that the relevant section referred to in Criminal Procedure Act be identified in the proposed paragraph Q of section 3, capital I of the Act, and the use of the word relevant section must be deleted and substituted with a precise reference to the applicable provisions of the Criminal Procedure Act. From the DOT side or Department of Transport side, we are saying it's noted and accepted, and therefore the consequential amendment in terms of specifying those applicable section of the Criminal Procedure Act would then have to be inserted into the bill, Chairperson. Chair, if I move from the slide 15 and go to slide 16, wherein there were no suggestions, but the comment was that the omission to insert or indicate expressly the relevant section or the specific section applicable in terms of the CPA creates an interpretational burden on anyone, particularly lay members of the public, in attempting to understand or figure out these particular provisions. And as indicated in my response in slide 15, Chairperson, I think we are in agreement with regards to obviously then specifying the applicable section in terms of the Criminal Procedure Act and making those consequential amendment or making those insertion of the applicable criminal procedure sections that is applicable in terms of this one, Chair. If I step off slide 16 and move to slide 17, Chairperson and honorable members, the suggestion is to replace the word body with organization as follows, and unless such person or authority or organization is registered as a weighbridge operator or facility. And our response from DOT side is that it's noted and accepted, Chair, that particular amendment can then be effected on the bill as proposed. Chairperson, if I move from slide 17 and go to slide 18, the suggestion is that the correct wording in the body of section 5 capital J is as follows: desiring to manufacture microdot, supply microdots, or operate a microdot treatment center shall apply. And our response in this respect, Chairperson and honorable members, is that we note and accepted the suggested proposed amendment to section 5J of the bill, Chairperson. Chair, if I then step off slide 18 and go to slide 19, the suggestion is that subsection 1 be broken into 3 paragraphs, each dealing separately with the decision which may be appealed against. Amend the wording to read as follows: at the refusal of the Chief Executive Officer to register him or her as a manufacturer, builder, or bodybuilder or importer, or at the refusal of the MEC consents to issue the exemption. In terms of our response with regards to the suggestion, Chairperson, is we agree with the suggestions, and therefore the particular clause in the bill can then be broken up so that it becomes clear with regards to the specific functions that the Chief Executive Officer and also the MEC will be able to or are expected to deal with, Chairperson. So in principle, we agree with the suggestions as submitted, Chairperson. Chair, if I start off from slide 19 and move to slide 20, and I think it's just the continuations of the breaking up of that particular clause to say separate those functions so that it becomes clear who does what in the entire road traffic management process insofar as those functions are concerned. Chair, it goes up until slide 22, Then my response, Chairperson, will be on slide 23, wherein it is suggested that clarity be provided as to the rationale for not including national departments from applying for approval to operate a driving license testing center. And I think from our side, Chairperson, I think what we have tried to do is to say, in terms of the functions regarding the issuance of driving license, obviously this is the particular domain of the Department of Transport to a certain extent, and if we were to open up to other departments to be able to issue driving license, it's just going to be challenging for us as the transport family to try and regulate that particular functions, which are then conducted by other departments if they are not transport related. The question in point, Chairperson, relates to the issuance of driving license by SANDF members, to the extent that in terms of practice and legal mandate and protocols within, for instance, Department of Defense, there are certain things that members of the public or any officials who's not a member of the SANDF may not at any given time enter the premises of the South African National Defence Force. And if ever the National Defence Force is then allowed to issue a driving license, it becomes challenging for the inspectors to go and inspect those facilities with regards to whether those driving licenses are issued in accordance with the provisions of the National Road Traffic Act, and also that the standards that have to be applied with regards to the issuance of driving license is adhered to by those particular departments, for instance, SANDF. And if we are to then advise any institutions that we are coming to do inspections or investigations, it then defeats the entire objective of us ensuring that we are able to root out fraud and corruptions within the issuance of driving licenses. So, Chair, our submission is to say the issuance of driving license falls under the portfolio of the Department of Transport and Provincial Department of Transport. Therefore, if we are to extend the issuance of driving license to other departments, it's just going to be challenging because those institutions' mandate or national government departments' mandate are not in the space of issuing of driving license, Chairperson. So that is why we would wanted to retain these particular functions within the National and Provincial Department of Transport. I submit, Chairperson. Chair, if I then step off from slide 23 and move to slide 24, which is the continuations of our rationale not to try and open up the issuance of driving license to other Department of Transport, is just to give a clear explanation of why we wouldn't want to extend the issuance of driving license to other departments, Chairperson. If I step off, Chairperson, and go to slide 25, the suggestion that was provided that it is proposed that the wording "no Department of State" be retained. And as I said, Chair, noted, however, the problem of issuance of driving license or fraudulent driving license and perpetuation of fraud and corruption in the DLC that can be otherwise be referred as non-departmental DLTC or unconventional DLTC prompted this amendment. This is compounded by the fact that, as I indicated, Chairperson, in my previous response, that some of the departments have their protocols that one needs to follow, and therefore it becomes challenging for us as the National and Provincial Department of Transport to be able to access and those facilities or those government's department without necessarily having to advise or inform them that our provincial inspectors or national inspectors will come and do inspections, and therefore we are not going to be able to curtail and deal with fraud and corruptions within the issuance of the driving licenses space, Chairperson. Chair, if I step off from slide 25 and then move to slide 26, where it is suggested that this instances measures be introduced to combat fraud and corruption. And third, for example, by stipulating that these motor vehicles be fitted with cameras and other necessary equipment. It is noted, Chair, and is accepted. And I think from our point is that it's important that since we are moving to the technology, the use of technology, any technology that will assist us in road traffic regulation and management will be of good importance or will add value to how we regulate and manage road traffic and road traffic management within the entire transport services that we render. So we do not have any objections if ever there is that particular requirements to say technological equipment should then be installed in some of these vehicles. However, there is cost implication that we must also consider in terms of those requirements, and also to the effect that at what point do we then require those technology, because if we are to require the technology be fitted aftermarket, it becomes a challenge because it has a bearing or may affect the warranty of those particular motor vehicles from the manufacturer's perspective. So if ever that particular requirement was to be included, it would have to be included at the manufacturing point of that particular motor vehicle so that you do not affect any warranty in terms of electrical or whatever modification that is subsequently done to a motor vehicle once it has left a manufacturing plant, Chairperson. Chair, if I move from slide 27 and move to slide 26 to 27, the comment was that insert the word learners as follows: the MEC concerned may, after such learner's license, driving license. And our response, Chairperson, is that we note and accept the proposed suggestion in terms of the signatures that needs to be inserted, therefore. If I step off from slide 27 and move to slide 28, the suggestion is that the correct drafting error in section 58(3)(b) is as follows: in the case of any such firefighting vehicles, fire lighting response vehicles, while such person is responding to a disaster as contemplated in the Disaster Management Act 57 of 2002, we note the suggestion, Chairperson and honorable members, and we agree with the proposed correction of that particular clause, Chairperson. If I move from slide 28 and move to slide 29, the suggestion that vehicles shall be fitted with a device capable of emitting a prescribed sound with an identification lamp as prescribed, and such device shall so be sounded, and such lamp shall be so operated while the vehicle is driven in disregard of road traffic sign. Chairperson, I think we note that and accept that because it will then ensure that those sirens and lamps that are switched on are able to warn the general public with regards to those particular motor vehicles, and the other road users are able then to avert or avoid colliding or causing an accident by not realizing that there's an emergency vehicles that requires to pass that particular motor vehicle. If I step off from slide 29 and move to slide 30, Chair, the suggestion is that we should delete the word "a" of that particular clause, and in that aspect, Chair, we note and accept the proposal, and we therefore saying that amendment can then be effected onto the bill, Chairperson and honorable members. Chairperson, slide 31, the suggestion is that reincorporate must be reincorporate. Obviously, we note that suggestion, Chair, and that amendment can then be effected on that particular clause, Chairperson. If I move from slide 31 to 32, the suggestion is that the line indicating the start of the proposed text should include the heading and not only the first sentence, since the text in the heading is also part then of what is being amended. And Chairperson, we note the suggestions, and we are in agreement with the proposed suggestion and the amendment of that particular clause to ensure that it's quite clear with regards to what needs to be the heading of that particular section. Chairperson, I think what follows then is the comments from Salga from slide 34, wherein if I go to slide 35, Salga supports the proposed changes with the consent raised with which can be addressed by the select committee, of which we then note the comments made by Salga, and for the select committee to then make their input with regards to the bill as submitted, Chairperson. The comment in terms of the Salga was that the matter further potentially complicated by the governance structure of the RTMC, which has the shareholders committee, the board of directors, and the executive management led by the chief executive of the RTMC, Chairperson. And that's how the RTMC Act was designed, that because the functions that the RTMC is supposed or is responsible for, or the object of or the purpose of the establishment of the RTMC was to ensure that it can pull all those functions that are residing at provincial and local authority level into one structure. That is why there was a need that the responsible MECs and Salga, who are responsible for those particular functions at provincial and local authority level, become part and parcel of the shareholders committee in terms of ensuring that the strategic direction of the RTMC takes into account the strategic direction of provinces and local authorities. That is why the governance structure of RTMC was such that those principals that are responsible for those functions at provincial and local authority level are given strategic direction insofar as it relates to the functions of the RTMC. And because they are at the executive level, Chairperson, it was important that there is a board that obviously then operationalize what the shareholders committee would have given direction or strategic direction in terms of the approach or how the RTMC is supposed to operate. So the Board of Governors, Chairperson, is intended to be the tool that the shareholders committee use to ensure that the RTMC operates in line with what the shareholders committee has mandated it to do under the leadership of the chief executive officer, Chairperson. If I step off to and move to slide 36, There's always a concern of accountability when legislation provides direct powers to the CEO without providing a clear mechanism of how the CEO will account for such as execution of function. Ideally, the legislation should tie such accountability to the existing provisions of the RTMC Act. As amended, and as I said, Chairperson, I think in my response with regards to the governance structure, because the strategic directions of the RTMC resides with the shareholders committee, which comprises of all the 9 MEC and SALGA to a certain extent. It's common cause that insofar as the functions of the CEO, they cannot go beyond those functions that have been allocated or ascribed to him by the shareholders committee. And obviously the shareholders committee would not also then give the CEOs unfettered powers such that he is not accountable to anyone in this respect, Chairperson. So there is that structure being the shareholders committee that would make sure that the CEO of the Road Traffic Management Corporation does not abuse the powers that has been delegated or ascribed to the CEO, Chairperson. Chairperson, in terms of from the DOT side, that is the responses that we are submitting to the committee chairperson in terms of the suggestions and inputs that we received from the committee chairperson. I submit, Chairperson. Thank you.
Thank you, Mr. Mtasim, for the comprehensive responses to the issues that were raised during public hearing. Let's hear from the Legal Advisor Committee Secretary. Can you guide us there?
Thank you, Chairperson. I see Ms. Ngema.
Thank you. Any point that you want to raise, Ms. Ngema?
Greetings, Chairperson, and everyone in the House. I hope I'm audible. Chairperson, basically, I don't have much to add, but just to note that it appears that the concerns and the submissions as well as the responses to the department are more to a technical nature and the drafting styles, which we will look into when we prepare the C list if the committee so decides after the deliberations. But as I said, generally, these appear to be the drafting style preferences, and then we will check against the conventions as well as the existing law, especially in respect of the schedules and their additions, the schedules to the Criminal Procedure Act. We will consider those with the direction of the committee. Thank you, Chairperson.
Oh, thank you, Ms. Ngema, for that response. Let's open the floor for members. Any clarity-seeking questions, deliberations that members want to raise? Let's say clarity-seeking questions from the responses by the department. Maybe let me break the ice.
Chairperson.
Yes.
May I request Mr. Mutsatzing to take off the presentation off?
Okay.
My apologies, my apologies, Honorable Chair, honorable members. I'm not computer. I try, but I'll try and take it out, Chairperson.
Can Enrico help so that our meeting is not disrupted? Just a few from my side. A few from my side. Just want to make sure, yeah. On the Mr. Mzasin, can you mute? Just on the retrospectivity issue, on the because you know that the department has welcomed suggestions from the Western Cape Government Department of Mobility that clause C6D should not limit the offences to those included in Schedule 1 and 2 of the Criminal Procedure Act, because clause 6D deals with the suspension or cancellation of the registration of an examiner for driving license or an examiner of vehicle in instances where such a person has been convicted of the mentioned offences. So therefore the suggestion, as you have said, is that the suggestion was made that Schedule 5 and 6 offences also be included. Now the question is, what about the concerns around the fact that conduct cannot retrospectively be made a crime? Doesn't that also apply in respect of contravention of clause 6D? Will this mean that persons convicted of offences but already employed as an examiner for driving license or an examiner of vehicles cannot, as a result of clause 6D, lose their registration or be suspended? Clause 6D will then only operate against persons wanting to register after the envisaged Amendment Act has been passed, or persons being convicted after the envisaged Amendment Act has been passed. Does the department have an estimate in terms of how many persons convicted of crimes contained in Schedule 1, 2, 5, and 6 that are currently employed as examiners for driving license or an examiner of vehicles? The second one relates to the points that were made by COSATU during the oral submission. Both COSATU and the Medical Research Council, led by Professor Perry, they made submission supporting a 0% blood alcohol concentration for drivers. And Professor Perry provided indeed his international accounts and examples. Now the question is, having considered the research on the impact of reducing blood alcohol concentration on road fatalities, what is the department's view on the current permissible blood alcohol concentration levels? I think it's important because the 0% blood alcohol level was indeed included in the earlier version of the bill. So just to probably get a sense as to whether should the committee want to pursue this further, what will be the view in relation to the amendments beyond the object and scope of the bill. I think also the issues around the definition of disaster in the Disaster Management Act is a bit categorical in terms of what does that entail. But I think what is critical is the inputs that were made during public participation around clause 40, which is open for potential abuse and create a safety risk on roads. Because the provision is to the effect that any vehicle driven by persons responding to a disaster as contemplated in the Disaster Management Act may disregard the directions of road traffic signs, which is displayed in the prescribed manner. So now the question is, what safeguards will be in place to prevent the misuse or abuse of clause 40? The next question relates to the concept of standard, because there are proposals that were made by Mr. Paul, and the department has not responded to that, because in terms of standard, it means any code of practice, compulsory specification, standard or standard method adopted by the South African Bureau of Standards. And also in terms of the way bridge facility is also defined. So now the question is that the department has to get a view in terms of their views on that. I think what is critical is that it's also the fact that the department also did not respond to what Mr. Makomo proposed in relation to that, and the department did not respond because Mr. Makomo's input was that the committee should consider to widen the scope for the approval and monitoring of embossers and allow for more accredited certificate bodies to participate into this sector or market. Therefore, instead of just calling for the SAPS approval, the regulation should call for approval by an accredited certification bodies. An example was made in relation to the role of SAPS and also SANAS, which is South African National Accreditation System. And also this elaboration was made in relation to the agencies of DTIC, because both SAPS and also SANAS are their entities. So if the accreditation is broadened, it will bring also better monitoring of blankers and embossers. For example, the Department of Labor has done away with this. The Department of Labor has removed the call for SAPS approval on fire extinguishers, and it replaced it with approval by accredited certification bodies. Secondly, also, they said the advantage of this is that it improved the monitoring and created choices for those involved in the servicing of fire extinguishers. The National Regulation Credit Services did the same by removing the call for SAPS approval for companies applying for letter of authority. Again, this improved monitoring of all regulated products and allowed for better services to the industry, as they now have more choices in terms of who can approve their products for compliance. So the question is as to whether the department has a view in relation to broadening the scope in relation to who can approve their products. Then the last one relates to the presentation by the South African Driving School Operators Association. They made a proposal as follows: that the association is of the view that clause 22B is prejudicial to the driving school industry. If driving license test centers provides a motor vehicle, then the authorities will be competing with the driving schools. Their concern is that the struggling driving school businesses could be negatively impacted. And they say that the people who are employed by the driving school industry might lose their jobs. And this could lead to a rising of corruption. So they see this as an unfair competition that might arise as a result of the amendment. And also this could also create unrest at the attempt by the department to implement. Maybe just to get a sense from the department, what is their view in relation to the presentation by SAG, South African Driving School Operators Association, in relation to clause 22B. Over to you, Mr. Mutsatsing.
Thanks, Honorable Chair, Honorable Members, for the questions. And I think maybe let me just respond with the first one with regards to retrospective applications of the proposal. Obviously, it's accepted that legal precedent that the law would not have any retrospective application insofar as it relates to what was approved. And therefore, it would not affect those ones that are currently, although undesirable, because if it's then found that some of them do have those offenses, it's just going to be an undesirable situation. However, in terms of the application of the law, it cannot have a retrospective application. It will only then be applicable henceforth. And I presume that in terms of the process that MECs have to follow with regards to approving the registering the application or applicants for examiner, for driver's license, and all those things, some of the requirements that we are trying to clarify in the current bill, the MEC would be able to, or is required to, make those considerations to satisfy himself or herself that that particular applicant is fit and proper to operate within that particular environment. So, Chairperson, in terms of the current bill, it won't have any retrospective application, and therefore we are fine in that respect. In terms of how many persons are within the current system that do have those or have been convicted of those particular offenses, I think, Chair, we haven't done that assessment as yet in terms of looking at the current examiners for driver's license and examiners motor vehicles that have criminal offenses. But in terms of the requirement of how they are registered, one of the requirements is to say that they must then provide the MEC with any criminal offenses that they have been convicted of. So I think to the extent that they may have criminal offenses is not related to what is currently prescribed in the current applicable legislation. So they may have some offenses, but which are not of what we are trying to prescribe for now, Chairperson. If I then go to the question of COSATU and insofar as the alcohol contents, I think from our side as Department of Transport, it would have been ideal for us to do away with the alcohol contents because of the practical challenges that we have with alcohol in the entire road safety environment, because our studies or the RTMC study shows that alcohol plays or contributes to a number of fatalities or accidents that we have on our road, and therefore, as Department of Transport, we would want to see that the intake of alcohol and driving a motor vehicle should be dealt with, and depending on what the committee decide, for us it would be an ideal situation that that consideration of retaining the restriction of alcohol to 0% is then reintroduced. We note the practical challenges that would have been raised by other sectors in terms of the alcohol within some of the food or anything that we intake, because there is that particular percentage of alcohol in those particular commodities or food product that we eat. And I think it's just a question of how then in the space of road traffic or road traffic management do we deal with that particular aspect of the alcohol contents in any food that we digest. So Chair, in principle, for us, it would be ideal that the restriction of alcohol be retained to a certain extent. In terms of the question that was raised with insofar as standards relate, I think obviously from transport side, I think the current practice is obviously for the SABS as the standards body and the national regulator for compulsory specification being the responsible authority that obviously manages those particular standards. And I think it's the domain that falls within Department of Trade and Industry that would then have to look at how then in the context of the Standards Act would they then allow for any certification or accredited body that provides for certification of or compliance to a particular standard. So in terms of our legislation, we refer to an authority which is SABS and the National Regulator for Compulsory Specification insofar as it relates to the Standards Act. Now, the question therefore that comes to say, open it up and have any other approved or accredited standard body to be able to ensure compliance. I think it's not within the transport domain. It's obviously from the standard side to say to what extent do they then accept or acknowledge that an authority or body would then certify that a particular product complies with a particular standard, and what mechanism is then used in ensuring that that particular body or organization complies from a certification or a standard certification body. This relates also to the SANAS process to a certain extent, because in terms of the standard SANAS requirements, if ever an institution is then accredited to be a certification body, I think, and they comply with the SANAS requirement, and I think that process would be followed. But I think the dynamics or the challenge would therefore be insofar as the certification and the certification insofar as it relates to the standard as contained in or as prescribed in the National Road Traffic Act, and also that complies with the National Regulator for Compulsory Specifications, whether those accredited certifications body complies with what's the Standards Act and the NRC Act provide for. I think that falls outside the domain of transport to a certain extent. But if ever those institutions then say you are able to open it up because there is certainty with regards to accreditation or certification by those particular institutions, and the Standards Act then says these are institutions that can certify a product insofar as it relates to its safety to be used by the general public. From transport side, we take cue from what that particular legal framework provides for. In terms of the question relating to driving school, Chairperson and honorable members, we note the reservations raised by the driving school sector, but to the extent that the DLTC operated by local authorities and provinces do not necessarily go beyond the testing of drivers at any given time. In terms of the practical operation, the driving schools would still proceed with what they are currently doing in terms of training prospective drivers of how to drive a particular motor vehicle before that particular applicant is then submitted for testing purposes. I think the intention was therefore, insofar as it relates to the testing, not the training of a driver to drive. That's the domain of the driving school sector. But in terms of what was envisaged is to say, if you were to be submitted for a test, the DLTC would provide you with a particular motor vehicle, and then you are then tested or examined that you are skilled to drive using a DLTC owned motor vehicles. But we note the proposal from the driving school sector, and that's what that particular clause is intended to try and address, to say there is the testing and there is the training, and the DLTC does not get involved in the training. It only then deals with the testing when that particular applicant is submitted for to undertake a test, Chairperson. I submit, Chairperson.
Thank you, Mr. Mtsatsin, for the responses to the clarity-seeking questions. I note there is a hand raised by Nolovuyo Tafeni and Pumelela.
Okay. Thank you, Chairperson. Chairperson, okay, greetings to the members. Chairperson, I'm not asking any question, Chair. I only requested that the Secretary please must forward all of the bills to my email, because I don't have any background of those bills. It's only Honorable Brenda that was received the bills. So after that, I will have a stand as organization. I thank you, Chairperson.
Thank you, Honorable Tafeni. I apologize for that. I hope the committee secretary will take heed of your humble request. We also agree that you need to receive documents, Honorable Tafeni, because you are a full member of the committee. Can you just clarify that, committee secretary?
Thank you, Chairperson. Well, the request is noted, Chair.
Thank you. Thank you, Honorable Tafeni, for raising that point. It's well received.
Thank you, Chair.
Mrs. Ngema?
Thank you, Chairperson. I just wanted to add a bit into clause 22 and the question that you raised. Clause 22 and the sector for the driver, the driving centers that assist people to get the licenses. It is in fact in relation to the amendment of section 18.2 of the existing act. And I think the members should also note that the question that the association is raising could be the same question arising on the part of the applicants. Because I think if we read the principal provision, it was basically indicating that the applicant brings their own vehicles for testing purposes. But what the provision was then trying to do is to bring an instance where an appropriate vehicle could not be supplied by the applicant, the center could provide for one. But I think what the drivers associations are raising is the issue that will monopolize the market. And what if the driving centers end up being the only ones that provide the vehicles? So they are querying the issue of a balance there, a balancing exercise. Whereas on the same light, the same can be applied. What if the associations are charging exorbitantly for the supply of the vehicles for the applicants who wants to get licenses? So just, Chairperson, a note there as the members will deliberate to consider that in that regard. Thank you, Chair.
Thank you, Mangema, for that elaboration. I hope the department has also then grasped the context and the background against which the point was raised. Then I think in the absence of any elaboration, let's then take this opportunity to express an appreciation to Mr. Mutsatsing on this responses to the national road traffic amendment bill, B7B of 2020. We can then move to the second one, which is basically a bill that was referred to the committee in terms of Rule 29 of Parliament of the Republic of South Africa. Let's get the response of the department to the oral and written submission on the National Land Transport Amendment Bill, B7F of 2016. As members will remember, this our task is to specifically address the reservations that were expressed by the President of the Republic of South Africa, who was acting in terms of Section 79 of the Constitution of the Republic of South Africa, 1996. Let's then give over to, is it you again, Mr. Mutsatsing? Yes,
No,
Mr. Similani.
no, Chairperson, thank you. Let me just thank the committee and honorable members for the opportunity given to us. But insofar as the other bill, Chairperson, Mr. Similani will then take through members through that particular bill, Chair. I submit.
Thank you, Mr. Mthatsi. Mr. Similani, the floor is yours.
Morning, Chair and the honorable members. I've just shown my face just for the benefits, Chair, for you and the members. Yes, can you see me, Chair?
Yes, Mr. Similani. We can definitely see you. You can hit the ground running. We understand.
Thank you, Chair. I'll then switch it off. If I can be given rights, Chair, to share my screen as well, my reply.
Mr. Similani, the rights has already been granted. You can proceed.
Thank you, Chair. And the members, I hope I'm loud enough, Chair. You can hear me well?
Yes, we can hear you. Thanks, Mr.
Thanks a lot, Chair. Thank you. Chair, yesterday we received a late comment with the link. Also from a letter which was from SALGA on top of the submission that they had submitted before with the other comments here. So we had to also just add a bit, Chair, from the previous submission that we did to the committee last time. So we've just did it overnight, Chair. So I've forwarded as well to Ntate Mthileni. Yeah, we just added a bit, Chair, just to expand on our reply on what SALGA was trying to do. We saw they were lobbying strongly the committee on the issues of the constitutionality of this bill. Yes, thanks, Chair. So I've provided again, Chair, yes, as I said, the submission to Ntate Mthileni for the benefit of the committee. However, Chair, I must just say through your guidance, as you have said, Chair, that we are responding on the referral of the matters of the President's, Chair. I will just do exactly that, Chair. With my thorough collection, Chair, browsing through the comments that we received from the different stakeholders, Chair, just broadly on a simpler ones, Chair, just to give an overview of all the comment was that we had received a strong comment from SALGA and the City of Cape Town regarding the referral matter to the President. However, then we replied, Chair, we've been working with Parliament, the various committee, that is PCOT and NCOP, to remove that clause 7, which was regarded as unconstitutional, Chair. We agreed then with the comments that were received and also as the guidance of the senior counsel from the Presidency that the powers and function on contracting must be left where they are within the local sphere of government. Therefore, we then removed that clause 7, Chair. So, Chair, then on the comments, we noted, Chair, that then therefore SALGA and the City of Cape Town, then they were now happy with that we have removed the clause 7. When you read broadly what the City of Cape Town was saying, they were now at least comfortable with the way we've dealt with that matter as well as SALGA. However, then, Chair, SALGA then went on to raise all other issues outside of the referral matter of the president, particularly on section 5.6, to say that they also regard that section to be in line with what the president says in terms of clause 7. That is also constitutional overreach, Chair. But however, also with that, Chair, we also just did a reply on that matter. And also then Bolt, Chair, were just on their comments, Bolt were just flagging the challenge that they have in terms of the e-hailing, because Bolt is one of the app companies that their platform is being used by operators and also the traveling public to request vehicle into their services. So then Bolt, then they were just complaining, Chair, the kind of challenges that they have in the lack of regulation by government on the e-hailing service. But however, just commending the process that has been started by the committee to fast track this bill, so that then their industry can also then be regulated and find traction into the National Land Transport Act. So they were just commenting on that, Chair, and then pleading with the committee if this process then can be fast-tracked, so that then there will be peace in the public transport space. So we also received from Western Cape, Chair, and also Golden Arrow, Western Cape Province, and then the City of Cape Town. Then on the overall, Chair, I must say we did go through the various comments. There was nothing much that touched on the matters of on the referral matter by the presidents, as the department responded positively and removed that clause in acknowledging that, Chair, yes, probably the issue that we have put in to say certain municipalities will need to qualify through a criteria in order to undertake contracting functions was going to be an obstacle on their part when they are doing their services. So we acknowledge that, then we remove that, Chair. And also that we also had another provision within the same clause 7, then to say that others will then need to apply to the minister to be exempted for not qualifying through a criteria. So all those which were seen then, Chair, even by the presidents, that they were going to be probably stumbling block or a hindrance into the local sphere of government when they are undertaking contracting functions. So we remove those, Chair. Then most of the other provision then, Chair, on the comments by the different stakeholders, they were out of that referral matter, Chair, except for then SALGA, that they were still yesterday on that letter. They were lobbying strongly the committee to say maybe section 5.6 also need to be looked into, because it also seemed to be in the similar vein with the clause 7. However, then, Chair, as you can see there, we provided just our comment to say section 5 of the Principal Act must be read in the spirit of section 154 of the Constitution, which requires the national government to support and strengthen the capacity of municipalities, as well as section 11(1)(a)(4) of the Principal Act, which requires the national government to capacitate and monitor municipalities that lack capacity. We also just added, Chair, to say it must also be read in light of section 41 of the Constitution and the Intergovernmental Relations Framework Act 5 of 2013, which require the spheres of government to work together in mutual trust and good faith, and to coordinate their actions. The intention of section 5.6 is not to enable the minister to take over and perform municipal functions, which will be unconstitutional. The intention is to empower the minister to engage with municipalities to monitor the performance of their functions under the Act, and to assist and capacitate them when necessary. What happened now? Hey, are you still there? Hello?
No, we are with you,
Network is good.
Mr. Similani.
Oh, thanks, Chair. I just saw your screen. Your screen just disappeared on my radar this side. So I thought maybe I got cut off.
No, we are still together.
Okay, thanks a lot, Chair. Then I was just on that line, Chair, to say the intention of Section 5.6 is not to enable the minister to take over and perform municipal functions, which will be unconstitutional. The intention is to empower the minister to engage with municipalities to monitor the performance of their functions under the Act and to assist and capacitate them when necessary. Directives issued in terms of Section 5.6 are intended to advise and assist the municipalities in performing their functions by stating steps required for them to do so, not for the minister to take over the municipal functions. Also, Chair, in the Constitution, Section 5.4, Section 5.4, one of the Principal Act must also be read in the same light, Chair, because they are also complaining with the same section, with the similar section, Section 5.6 and then 5.4. Then we just responded again on Section 5.4 to say that Section 5.4 must also be read in the same light. The minister is empowered to advise on and assist with the establishment of integrated public transport systems and not to take over the function in terms of the Constitution. In terms of the Constitution, Chair, all three spheres of government are responsible for public transport. It is a concurrent function. They must work together to ensure the provision of efficient and effective public transport in the community. The intention is thus for the minister to work with the municipalities to achieve this objective, not for the minister to encroach upon municipal functions. And also, Chair, we just added Section 1557 of the Constitution that it also empowers national and provincial government to have legislative and executive authority to see to the effective performance by municipal on transport matters, which are outlined in Schedule 4 and 5. So that is our response, Chair, to the strong lobbying that SALGA was further forwarding to the committee after we've corrected the clause 7, which was the matters that were referred of the referral by the president. So it is in that line, Chair. I think our lessons, Chair, from the department side, we have learned on this referral matter. It was a lesson also to say each sphere, although this is a concurrent function, but each sphere enjoys its jurisdictional authority over its boundaries. Therefore, if any other sphere it's coming to assist, it must approach it carefully with some intergovernmental relations framework or some cooperative government spirit. And also in our Principal Act, Chair, we've got Section 12.1, where it says that the province, if there's some capacity gap in certain municipalities, particularly in the rural areas, they can then invoke Section 12.1 and enter into agreements with municipalities to undertake those functions, which must be agreed upon in terms of the time frames, as well as to how long they will be running that function on behalf of the municipalities, and also capacity arrangement be undertaken so that at that time, when then the municipality takes over that function, then they will be ready to take that function. So, Chair, that is our brief submission, Chair, in line with all the other comments that we received, Chair. Thank you.
Thank you, Mr. Similani, for the response to what SALGA and the Seal of Cape Town Board were saying. And therefore, in relation to the issues raised around clause 7. Clearly, you have indicated that there is a lot that the team has learned from the referral. That each sphere is distinct, but they are independent. They are interdependent and they are interrelated. I think that is the message that you are saying, that there is a lot that you have learned from the referral. Let's check whether Mayor Ngema would want to say a word or two.
Greetings once again, Chairperson. I think what I just need to point out, Chairperson, without going much into the details and substance, because I'm in agreement with what the department has pointed out and indicated. It is just for me to speak on the procedure, just to clarify the committee, that if we check the joint rule 209(2) and 3, in light of what the committee is deliberating on and doing, basically, if we look at 2093B and what has happened and the submissions or responses from the department and the submissions received, the rule there is guiding the committee that if the committee agrees with the president's reservations, the committee must report whether it agrees with the amended bill passed by the Assembly, if the Assembly has passed such a bill, or recommend rejection of that bill. So what transpires, or we can deduct from that rule, Chairperson, is that there are two options that are before the committee, because as we understand, we are now on the F bill, which is the bill that has been amended by the National Assembly after the reservations of the president were considered by the First House. So what is open to the committee is basically to do the deliberations as has been done and decide whether it agrees with the bill as amended by the First House in taking into account the reservations, or whether it rejects that bill, Chairperson, because it doesn't look like there is an in-between for the committee to decide whether to make any further amendments in that regard if one reads the rules, as well as in line with the Mpumalanga Petition Constitutional Court judgment, Chairperson. So those are unfortunately the restrictions that the committee has in respect of proceeding and taking into account the submissions that have been submitted. That said, Chairperson, I am satisfied that the responses of the department, in light of all the submissions raised and the reservations that were raised by the president, that has been addressed and the committee has dealt with the process properly. I thank you, Chair.
Thank you, Mangema, for that. Any clarity-seeking questions from members? I think Mangema has made it much more easier for us, and also the department in terms of the guidance. The responses by the department to the referral by the president, there is consensus on that. I guess in the absence of any engagement on this, on the presentation, on the responses, which is mainly around agreeing with the responses that the referral that was raised by the president in relation to the presentation by SALGA and the City of Cape Town. There's no confusion. I guess that the members are happy. Let's then take this opportunity to thank Mr. Similani for the clarity of thought that he gave, and also Mangema for the clarity she provided in relation to the responses, in relation to the presentations that were made. It's quite clear that members have no clarity-seeking questions. And then I believe that from this, there will be another platform where members will deliberate, and then the committee take agree on the process to follow. But clearly, for now, there is no confusion. Thank you, Mr. Similani, for that clarity. I mean, for those responses. Thank you also, Mr. Ngema, for those responses.
Thank you, Chair.
Thank you. Committee Secretary, it looks like we are done now with the responses. I just need guidance from you in terms of the next presentation on the responses, because the department did make a presentation on those responses. What is holding us now is the presentation from the legal services. You said they are engaged somewhere. Can you give us clarity on that?
Yes, Chairperson, that's correct. Maybe what if the committee feel that they can proceed without the legal advisor, because given the time, or we can also propose that it is we wait for her, then we pause this meeting. We can maybe agree what time we can be back, just after lunch. I'm not sure.
Yes. Yeah, can we then agree based on that we allow we adjourn the meeting for now and reconvene at 2? We hope by then the legal advisor will be available. Is that the understanding?
No, I think Chairperson. So asking the members.
No, is the understanding that she will be available at 2? That is the question that I'm posing to you.
Oh, yes. Chairperson, let me also bring my colleague, Dr. Clark, also to respond on that one.
Dr. Clark? Dr. Clark is muted.
Apologies, Honourable Chairperson, honourable members. Yes, the indication from the legal advisors is that other commitment is for the morning, and in the afternoon you would be able to dedicate to us, Chair. The draft program at the moment has us back at 2:30. So at the program we provided to her, Chair. So if I may suggest that we reconvene at 2:30 instead of 2:00.
Thank you, Dr. Clark, on that advice. I guess that members, are we happy with that? Let's reconvene at 2. No objection from members. Then let's then adjourn the meeting and reconvene at 2. Thank you. The meeting stands adjourned.
Before you adjourn the meeting, we'll be using the same link.
It will be the same link, honorable members, and also our guests on the platform will be the same link. Let's reconvene at 2. Thank you. The meeting is adjourned.
Recording stopped.
Chairperson.
Yes, Mayor.
Um,
Did you say 2 o'clock or 2:30?
we agreed on 2 o'clock, Chair.
Oh,
Yeah.
that's great. Is the legal advisor here?
Not yet.
Because I thought you said
Uh,
2:30.
let me
Let's
let me check with Dr. Clark. Dr. Clark.
Yes, I'm just contacting Ms. Khalkans on cell phone. I'll respond in a few seconds.
Okay.
And also the department, it's only Mr. Mutatsing was in here and he's not dealing with the ERT. So they haven't logged in. Let me also make follow-up too, so they can log in.
I thought you said 2:30.
No, you said 2 o'clock.
Okay.
But it's fine. It's fine. We'll wait.
Committee Secretary,
Chairperson.
is there any movement?
Yes, the parliamentary legal advisor, she is logged in, and also the state law advisor. Just call Tande to make follow-up with the department because now we are waiting for them. We can't proceed without them.
Okay,
Yeah.
bye.
Chairperson.
Yes, Rebecca?
We can start the department. It's logged in.
No, brilliant. Let's then again welcome the
Recording in
members.
progress.
Welcome the members back to our meeting started this morning. Remember that we adjourned at a time when we had the legal advisor responsible for this engaged in other activities, and we had already dealt with the other two bills. So now we will now be seized with the ERT, and in terms of the process that had started before we adjourned, there were already questions that were raised by Honorable Tim Platteser. But maybe what we could do, let's say, allow the legal advisor from Parliament to probably just share with us a reflection in terms of the responses that were presented by the department, and then probably engage. Alternatively, what you could do, if the team agrees, we could then open the floor for discussion. But it was important for us just to get a sense from Parliament what is their overall impression in terms of the issues that were canvassed by the public, but more than that, the responses that were given by the department in our last engagement, which was in September, just to get a sense as to whether from their side are they comfortable? Are there any issues that they would want to raise with us in relation to the economic regulation of transport bill, which is before us? Can you guide us, legal advisor?
Thank you, Chairperson. Good afternoon, Chair, and to all on the platform this afternoon. Firstly, Chairperson, let me thank you for the indulgence. I was involved in another committee with the climate change bill, which I've just stepped out of. So thank you for that indulgence to you and to the committee. Chairperson, so just in terms of the legal advisor's role in this committee, it will be purely to address legal concerns that are raised by the committee. What I would like to just point out, Chairperson, while I have the floor, is that pursuant to the department's presentation on the submissions, Chair, you will have noted that a lot of the submissions that were raised and that were addressed by the department were already dealt with in the NA process. So a lot of those concerns were already canvassed, but the department has gone through their responses, and I have no difficulty with their responses. But Chair, let me just say this, that as we go along, I will guide the committee in terms of legal questions and answers. The department will deal with issues of policy. I will not deal with issues of policy, and the state law advisor will deal with any concerns regarding constitutionality and so on. But we are all here to guide and assist the committee, and I thank you once again for your indulgence, Chair.
Thank you, legal advisor, Ms. Tiloshini Ganjen, if my pronunciation is correct. Let's then go back to the department. There was a general question that was raised by Tim. I believe that the department has captured that. Tim, can you can again reiterate the question?
Thank you for the opportunity, Chairperson, and thank you for the guidance from the legal advisory team. Perhaps I should just start there, Chairperson, just to couch my question. So Section 1C of the Constitution basically states that Parliament must refrain from giving the executive unchecked discretionary authority when enacting laws. And the problem that we have with this particular bill is that there are many clauses that provide the minister or the regulator with unchecked ability to make judgments based solely on whatever is guiding them at the time. It also gives them the authority to assign officials and specific instructions, and to give specific instructions to specific individuals. Now, that's all in terms of this bill, in the remit of the minister and the regulator. And our major concern is that this allows government to reach into the transportation industry. It allows the minister and the regulator to reach into the private domain without any justification. And the bill seeks to centralize government of power away from civil society and away from independent institutions, and put that all in the Department of Transport and its minister. And so that is our major concern, is that this bill presents an overreach which could be in conflict with Section 1C of the Constitution. And so maybe we can get comments on that from the legal advisory team, and then also get the department's response to that. And as I just pointed out earlier today, it also affects the ability of different spheres of government to regulate their tariffs, their permits, their fees, and this essentially is the problem that we feel might be problematic, especially in relation to the provinces that we represent. Thank you, Chairperson.
Thank you, Honorable Professor, for that. Maybe before we give over to the department, just few issues from my side. The first one relates to one of the point that was raised by Southern African Bus Operator Association in their input. One of the issues that they raised was clarity on the legal remedies that could be available to institutions or entities where harm, whether financial or otherwise, could be caused by the wrongful regulatory decision, and that those decisions are not reversed timeously as contemplated under Section 12.1. It would be important just to get a sense from the department whether are there any legal remedies available to entities. The second one relates to the input that was made by Professor Muller, and one of the issues that he raised was around the broad regulatory model. I guess regulatory model like probably NERSA in the electricity environment, our sector, and a view that was expressed was limitations and challenges, given the fact that challenges that were experienced in the electricity sector, and also a comparison was raised in relation to the same model, regulatory model in other countries, particularly in regard to the transport sectors. So the question is in relation to whether the department did some work in relation to reviewing the implementation of the broad regulatory model in other sectors, just as lessons to be learned, or also in other countries, just to tease challenges that could emerge, but also what are the positive aspects from those. The second one relates to the scenario planning, whether the department has undertaken scenario planning with the use of the model, example, water as a case study of how public entities can deliver well without an independent regulator. Which policies alternative were in fact considered, and why was the current model preferred? But also in relation to Transnet, one of the issues that they raise is the absence of a policy, whether it is through green or white paper, in relation to the transport sector, and which prompt them to say maybe what should have happened was probably the white paper first or the green paper first in relation to the economic regulation of transport sector. Because one of the issues that they raise is that such a policy position would have assisted the stakeholders to understand the conceptual direction and thinking around the proposed bill, which prompt the question as to whether will the department at some point look into the possibility of developing an economic regulation of transport policy, just with a view to ensure that there is clarity around the direction that the department is taking around this bill. The second one relates to, I think, in relation to service. There was an issue raised, I think, by the Western Cape government around clarity on the definition of services. Because they say that the current definition of service in the Act is activities involved in the transportation of persons or goods within the transport sector. So the question is whether the definition of service is integral to the scope of the bill, and whether the definition might need to be clarified for the avoidance of confusion or doubt. I guess the onus is on the department to make sure that the scope of the bill is clear and there is no ambiguity in relation to what is meant by service. For example, does service include also non-commercial services that could possibly be provided? The last one relates to I think it's the point that we raised, the issue of policy. In the absence of the policy, Transnet suggests that there is a need for elaboration in the form of a preamble, because in the absence of the policy, preamble can be able to state right at the beginning the intent of the bill and outline the broad principles contained in the particular legislation. So the suggestion is around it. I know that the department's response has been that the preamble is not used in an ordinary bill. It is used in the bill of constitutional importance. But the Transnet, I think, obviously now the question would be whether given the importance of this bill and its national importance, is that not necessary? Then I guess the issues of constitutionality was also raised, particularly in relation to, I think it brought us on the point that was raised by Tim, particularly in relation to the schedules. Both Schedule 4 and Schedule 5 of the Constitution makes a distinction between what belongs to local government sphere, what belongs to the provincial sphere, what belongs to national sphere, particularly in relation to possible conflict, where there are conflicts between national and provincial legislation in relation to Schedule 4 competence. Section 146 of the Constitution, I believe, has been raised in the past. But also, I think what will be quite clear is we take into account Section 4.1 of the Constitution and also Section 146(2)(b) and (c) of the Constitution, particularly in relation to their work as it pertains to the work of the province, where an impression could be that the province would be required to amend their legislation to conform with proposed amendments. I believe that's what the team is saying. Other than that, also, I believe clause 5.1.1 provides that the regulated entities will bear the cost of the regulator and the council, and Section 73(2)(a) and 77 of the Constitution of the Republic of South Africa set out the requirements of a money bill. So one of the issues is a qualifying feature of a money bill is that it imposes tax. The fact that the annual fee to be paid by the regulated entities will be used to fund the operational expenses of the regulator and the council means that it is a tax that ought to be imposed by way of a money bill as provided for in Section 77 of the Constitution. Just clarity around how do we get around that. Other than that, let's give over to the department to respond, and then also I believe thereafter give to the legal advice of the department. Is it you, Mr. Mutatsing, again?
Good afternoon, Honorable Chair. No, Chairperson, is my colleague Alan Chikamvi, who will be taking the committee through the bill.
Thank you.
Thank you, Chairperson.
The floor is yours.
I don't know if I'm visible from your side, Honorable Chair.
Yes, Alan.
Yes. Good afternoon, Chairperson, and good afternoon, honorable members. Thank you for allowing me an opportunity to take you through the responses on the areas of clarity, on the questions of clarity which you have raised, Honorable Chairperson, together with Honorable Bratised. I'll then start with responding to the questions which were raised by Honorable Bratised, to indicate that the first question which he raised earlier on in the morning, they raised an issue of the bill seems to take the functions of the municipal authorities. In response to that one, Honorable Chair, actually the response is that the bill does not take away the powers of the municipalities, as stipulated in Schedule 1 of the ERT bill, where we are amending clause section 28 of the NLTA. However, what it does is that the municipalities, according to the clause which will then be repealed, is that the municipalities will continue to impose the charges as per section 28, as I've indicated earlier on. And however, the only difference is that the charges that they may impose will be subject to determination by the regulator, which is Transport Economic Regulator, in terms of clause 11 of the ERT bill, which then further allows for a consultation process when it comes to determining that the charges which they will then be imposing. So the regulator will not be doing that exercise in silos. However, it's a consultative process. Together with the members of the public are also given opportunity to factor in their inputs in that process of determining those fees. But however, when you then go further look at clause 11.8, it then further indicates that the regulator must consider each price proposal on its merits. Again, the very same clause also allows for price control for an entity to be exempted from to fall under subject of the price control. So this is one question which then has to deal with the issue of the bill taking away the powers of the municipalities. However, going forward to the second question, which Honorable Bratty said has then raised regarding the issue of the constitutionality of the bill, whereby the regulator and the minister are being granted discretionary powers. Again, further then elaborate to say the bill intends then to reach out to the private domain, whereby you then approach a private domain and impose regulations likewise. So on the one of the issues of constitutionality, I'll then have to leave that one for our parliamentary advisor to then advise us accordingly. Because as far as we are concerned, as the department, the bill was certified by the Office of the Chief State Law Advisor that it is constitutionally sound. So I think that this one I'll then leave it for our legal advisors to then advise accordingly. Then with the one where it's referring to reaching out to the public domains, from our view as the department, when you look at clause 4, which then deals with application of the act, it's clear, Honorable Chair, whereby we have placed the conditions in which allows the regulator to then or allows the minister to can then determine that any private or public entity may fall under application of this act. Meaning that when you look at, like, for instance, clause 4.2 of the ERT bill, which then has indicated the circumstances which applies before the minister can then determine an entity to fall under application of this act. So I can then cross-reference by quoting what is stipulated on the in the ERT bill. So clause 2A then indicate that the circumstances which apply is that when a single operator controls more than 70% of the market content. That is the first condition which the minister needs to then look at. And then the second one is that the preconditions for efficiency and cost effectiveness do not exist in the market consent. So that is the second one, Honorable Chair. And again, it then further stipulates on clause 4.3 that the extent of regulation introduced must be proportionate to the competition's problems in the market. Therefore, it's not intended to just approach a single privately owned entity or infrastructure and impose regulations upon without looking at the proportion of the competition's problem within the market, Honorable Chair. Therefore, I think I've responded to the question which was raised by Honorable Bratty. And then I'll then take you through the question which you have raised, Honorable Chair, regarding the legal remedies which are affected in the ERT bill in order to stipulate what will happen should the regulator wrongfully make wrongfully makes a decision, which will end up affecting the regulator. So, basically, Honorable Chair, when we were conducting some of our international benchmark practices, we then realized that in some cases you find that the regulators were making poor decisions on the fact that you find that within the regulator they lack experience, there isn't enough capacity to can execute their functions, and there was also an issue of unavoidable human error which tends to happen within the environmental, the economic regulatory environment. And again, you'll find that the regulator made a decision in favor of the operators or political interests. So such discrepancies, we then picked it up, and then we then came up with we then structured the bill in such a way that we try to allow for regulatory transparency and to ensure that the regulators' decisions are fair, reasonable, and predictable. And this we then find it under clause 11.3 of the ERT bill, which then allows for the regulator to follow specific processes in determining the price control of the regulated entity. For an example, we realized that the bill caters for all modes of transport within the transport sector. And in order to cater for all the tariff methodologies, et cetera, we then crafted the bill in a manner that we do allow for a regulated entity to determine its own prices and make a proposal to the regulator. That is according to clause 11.3 of the ERT bill. Then after receiving that price proposal, then clause 11.4 then say when considering a proposal submitted in terms of this section, the regulator must then consult with the affected parties, determine whether the proposal is fair and reasonable after considering all relevant circumstances, including the regulated entities' efficiency and effectiveness, the need of investment and security of supply of the regulated market, the opportunity cost of capital, including average rate of return on other domestic or international facilities or services having similar or comparable risk, the actual or forecast cost of debit, any reasonable cost differentials between the different types of facilities or services provided arising due to geographical location or any other characteristics that the regulator may deem relevant, and the likely effect of the price control on the economy, employment, consumers, and small medium enterprises. And it then further stipulates that any advantages or disadvantages an operator has as a result of the state investment transfer laws and regulation, and any other specific criteria prescribed by the regulations. So basically, it means then the regulator needs to factor what I've mentioned in considering those price determination. But however, should then the regulator determines the price control which adversely affects the regulated entity, we then introduced clause 22 of the ERT bill, which then deals with issues of a review of the decisions of the regulator. So in that one, this then means that, Honorable Chair, the person that has been adversely affected has got a right to then go to the regulator and request for a review of the decision that has been made by the regulator. Then the clause 22 it further then stipulates the procedures in which the council need to then follow in considering the review. However, in some cases, we then realize that there are other decisions which the regulator which may make, and they need to be addressed in a speedily manner, because the impact that the decisions that they've made, you find that it is harming, is actually a threat to the operations and the efficiency of the regulated entity. Then within it's one of the areas which we then identified, which was going to be embedded within the regulations, to see that an entity is also allowed to can apply for a speedy decision making process on the matter, which they are adversely affected by. I think I've responded to the measures in which are in place regarding which guards against the regulator making wrongful decisions. Then I'll then take you through the general comment which was raised by, I think you indicated, Professor Muller and Muller, where the comment is regarding the models in which we opted for, whether did we review other policy alternatives in considering the model which we are currently proposing to have. Basically, and what other policies did we look at, which then informs us in establishing this transport economic regulator. So basically, when we look at the white paper, the white paper on national transport policy, it envisages that the government's role in regulating monopolies, which is normally through economic regulator, specifically in the state airports, the ports, and the road and rail concessions, and provides for the establishment of regulatory structures as needed. So, having said that, the national white the white paper on the national transport policy is an overarching transport policy which we currently have in place. And again, what then also informs the need for us to have this transport economic regulators, that the National Development Plan requires that the state must also put in place appropriate regulatory and governance framework so that economic infrastructure is operated, economic and infrastructure is operated efficiently, and tariffs can be set at appropriate levels. So again, once again, when we then look at some of the government's priorities, like for example, Operation Vulindlela, a transport economic regulator has been identified as one of the stimulus packages with regards to the socio-economic recovery. So those are some of the policy documents that then gives us the intent to then develop a transport economic regulator. Having said that, Honorable Chair, then the department then conducted numerous benchmarking exercise where we looked at numerous countries as well as other economic regulators within South Africa. So what we then realized is that when we look at the current status quo, which we are currently having, is that when you look at the aviation sector, for an example, the problem that we are having there is that we do have a regulating committee that is regulating the fees which are being charged by AXA and ATNS. But however, there isn't any independent appeals mechanism. Should AXA and ATNS be aggrieved by the decision which has been made by the regulating committee, there isn't anywhere where they need to go and then appeal for that decision. Therefore, which then allows us to then say by creating a transport economic regulator, it should be a full-time appeals mechanism for that regards. And then the other one, when you look at the roads within the road space, we then realize that SANRAL make proposals to the minister for determination of their toll fees. And the minister then will then have to approve those toll fees. Then we then realize that the minister is actually performing the economic regulatory function, which then needs to be sitting with the transport economic regulator, which should be a full-time body, who should be performing economic regulation within the transport sector. Again, when we then look at the rail space, within the rail space, there isn't any independent economic regulator at the moment. And again, there is also no independent appeals mechanism within the respective rail sector. Then we look at the maritime one. We have the ports regulator that regulates the Transport National Ports Authority. But however, how the ports regulator is structured is it is structured in such a way that the board is responsible for making day-to-day economic regulatory decision. And again, the board also is the very similar party where one needs to go and lodge a grievance once they are adversely affected by the decision which has been made by the ports regulator. So in that regards, we are, by introducing Transport Economic Regulator and Transport Economic Council, we will then be dealing with those issues of independence and transparency to say you can't be a referee and a player within the transport sector. So having said that, Honorable Chair, we then look at what other regulators, which model do we then need to take as the approach. Then one of the, we identified, we had actually 3 options. Option 1 was that we need to have each individual mode to have its own economic regulator. And then we then realized that given the fact that currently where we are sitting, there are already existing problems, as I've alluded earlier on, then we then saw that there's a need for us to then consolidate all the modes into a single transport economic regulator. Then what then informs us to say, is there any country that has a similar model which we then intended to adopt from? Like one of the countries which has got a similar model where they regulate all sector modes are under one regulator is the Canadian Transport Agency. Get together with the Swedish Transport Agency. Both they regulate all modes under all modes are regulated under a single institution, which is the economic regulator. But however, we then looked at Rwanda Utilities Regulatory Agency, where we then realized that the agency actually is a multi-sector regulator where they regulate issues of telecommunications network, communications. They also regulate, say, electricity, water, removal of waste products, residential and other business premises, extraction of distribution of gas. Can you hear me, Honorable Chair?
We are together.
Oh, okay. Now then,
it looks like there was a disruption from your side.
Oh, okay, Honorable Chair. No, so having said that, it's a multi-sectoral. RURA is a multi-sectoral regulator. It regulates almost all the sectors which needs to be economically regulated. So having looked at those ones, and some of them they are of a success, we then decided we then looked at our current economic regulators within South Africa, such as NERSA, your ports regulator, ICASA, Competitions Commission, National Credit Regulator, etc., Honorable Chair. Then in deciding the option now, which how this Transport Economic Regulator needs to look like, and together with the Transport Economic Council, we then had 3 options again on that one, Honorable Chair, where the option 1 was to divide the regulator into 2 independent institutions, which is the Transport Economic Regulator, which then houses the technocrats and skills required to regulate the sector, and the other one being the Transport Economic Council, which will then serve as the independent appeals mechanism for the regulator, which then reviews the decision which has been made by the regulator. So that was the first option, and then the second option was that we do have the Transport Economic Regulator and Council, which will then be retained as one institution. However, but now the regulator staff report directly to the council. That was the other model which we then looked at. That model, we find it working when you look at ICASA. And the first option which I indicated, Honorable Chair, that's the model which is currently being practiced by the Competition Commission together with the tribunal. So the second option then, which then makes it to be ICASA. And then the third option was that to adopt the model of NERSA, which consists only of the regulatory structure with the senior decision makers housed within the regulator. And the only available option for review of decision is to go to the normal court systems. Then what we then realized with option 3, Honorable Chair, is that when we look at the court system processes, they take they take long to conclude, because it's now dependent on the court systems. Therefore, you'll find that end users are adversely affected by the decisions which are by the legal processes which will be ongoing in this regard. But however, then the department we then decided to opt for option one, which we do believe that it then allows for regulatory independence and transparency. I think I'm done with responding to the question, to the general question raised by Professor Muller and Muller. And then the other one is the issue of whether we were supposed to start with economic regulation of transport policy rather than the economic regulation of transport Act or B. With this regard, Honorable Chair, like I've indicated earlier on, to say that when it comes to the policy issues, I've alluded earlier on to say the National Development Plan stipulates that there's a need to introduce economic regulation through setting up of prices and tariffs, etc. And also, I then indicated on the white paper on national transport policy to say that it's an overarching transport policy, which then envisages that there's a need to regulate monopolies within the transport sector and establish other regulatory structures which are needed. So having looked at this one, Honorable Chair, I think from my side, I think on the policy issue, we then realized that the question then further engages to say there isn't any respective policy that then informs us having to establish the transport economic regulator. And then our observation on this one, Honorable Chair, is that currently when you look in the maritime space, aviation sector, they are currently economically regulated. The maritime space is regulated by the Ports Regulator of South Africa. And again, the aviation sector is regulated by the regulating committee. And there are also other economic regulatory functions which are also being performed by air licensing councils, which then allows for access into the market. And when you also look at the road space, within the road space, we have a national public transport regulator together with those toll fees which are being determined by SANRA. So what we're then saying is that if the question which one could raise is that if there is a problem within how an individual sector is operating, then does that mean in the absence of policy you cannot put up remedies to try and address those challenges? So in response, the department will say that the Ports Regulator was not informed by policy when it was established from our side, again with the regulating committee as well. Therefore, when you look at the rail space, there wasn't any policy which was informing the establishment of a single transport economic regulator. But however, as the department, we've realized that there was a gap in that regard. Hence, you would see that the national the white paper on the national rail policy then stipulates that there is a need to establish an economic regulator that will then deal with that will then come up with the regulatory instruments and procedures really needs to be applied within the rail sector. And most of these instruments, those are instruments which are going to then be embedded in the regulations once the bill has been enacted. And within in developing the regulations, then the bill also stipulates that should then be a consultative process, whereby the minister is then supposed to then gazette the intent of developing regulations on a specific matter, and then members of the public are then allowed to comment, to provide their comments and inputs for consideration. And then I'll then take you through the question. The other question is regarding the definition of service. whether it's integral to the scope of the bill. So, Honorable Chairperson, on this one, when we provided our response, we did indicate that the definition of service, the intention is to the bill is intended not to define the term for all the transport mode, and yes, the term may refer to non-commercial services that could possibly be provided. And these non-commercial services, Honorable Chair, we have identified it as one of the key areas which then needs to be unpacked within the regulations during the process of developing the regulations. And again, when we then did our own benchmarking studies, when we looked at the term on the term service, I'm mixing the two with the one of the operator, Honorable Chair. So being on that one, I can then just creep into the one where it speaks about a need to then have the definition of operator, and then I'll then come back to the other ones, Honorable Chair. So on the one of the definition of operator, we then realize that it is standard practice that each word in the bill or act does not need to be defined. However, definitions captured in the legislative instruments are for the words that have material impact. And again, when you look at, we then further illustrated that the definition of operator can also be found in a related piece of legislation, such as the National Land Transport Act. Again, we indicated on the National Ports Act, where it defines the definition of operator as the licensed operator. And again, we've got the Air Traffic and Navigational Services Act, which also defines the definition of operator according to the aviation sector. So we then realized that there is no need for us to have a single definition for the word of operator, since the principal acts are providing for that definition, Honorable Chair. Then I will then go through the comment which was made by Transnet on the preamble. I think you have also noted, Honorable Chair, that the department did respond to say that preambles are not meant for ordinary bills, and then you then emphasized on a possible need for it to be embedded within the ERT bill. Therefore, on this one, Honorable Chair, I will then hand it over to our legal advisors to advise us on that one again, and on other areas which you have raised, which deals with the constitutionality of the ERT bill, because from our view, the office of the state law, office of the chief state law advisor has certified the ERT bill as constitutional sound. I think from here on, I will stop here, Honorable Chair. Thank you.
Thank you, Mr. Chikambi, for those responses in detail to the engagement by members. Let's check Mr. Tilo Shere before I give over to Tim. Legal advisor.
I'm here, Chair. Chair, so I wanted to speak very broadly over a host of issues, and if there's a difficulty with that, please just alert me. But I want to start with Schedule 4 of our Constitution. So Schedule 4 deals with the functional areas of concurrent and national provincial legislative competence. And Chapter 3 of our Constitution talks about cooperative government. It says that it is interrelated, we must cooperate with one another, and we need to coordinate their actions and legislation with one another. So Chapter 3 is quite seminal. It says coordinating their actions, government, and coordinating legislation with one another. So I think that's the central theme. Chair, Chapter 7 of our Constitution talks about, and more specifically, Section 151(3) says very clearly that a municipality has the right to govern on its own initiative the local government affairs of its community, subject to national and provincial legislation as provided for in the Constitution. And then I'd like to look at Section 154(2), which says that draft national provincial legislation that affects the status, institution, powers, or functions of local government must be published for public comment before it's introduced into Parliament or a provincial legislature in a manner that allows organized local government, municipalities, and other interested persons an opportunity to make representations with regards to the draft legislation. So, you know, our Constitution is quite incredible in that it makes provision for all these types of scenarios. But the long and the short of it, Chair, is that the ERT bill, as I understand it, is peppered with public consultation before minister makes determinations. It must be published in the Gazette, and quite important. You know, there was a concern about Section 41(b) and 41(c) about the constitutionality of those and the municipality needing to reform. And I think that the idea is that we want a coordinated, and we want uniformity in terms of legislation. We don't want a situation that we've had recently, you know, where there's a conflict between national and provincial, and it's an absolute mess. So I think the idea is just to create uniformity, and without encroaching, and the way in which it will be done is that there will be consultation. So and quite important, Section 44, I mean, it says advice and recommendations to the minister. So it's not that the regulator is going to be just running the show. There's going to be consultation. The regulator may advise the minister. The minister may or may not take that advice into consideration. So I think, you know, just as an aside, that is basically what I want to say, and it's not specific to any questions raised, but it's just in support of what the department, and in addition to what the department has said. And if there's anything else, the committee is welcome to raise it. But I would like to give an opportunity to the State Law Advisor. They were also instrumental in certification of constitutionality of this bill. So they are more than welcome to also come in if they'd like to add anything. Thank you, Chair.
Thank you, Siloshini. State Law Advisor, any input from your side? Rakasha, I see you are, but you're not audible. Raksha, are you sure? Let's, it looks like there's an issue. Tim, I see your hand is up. I guess it's a leader's hand. It's a leader's hand. I want to believe that.
Chairperson, I'm here.
Yes, Tim.
My apologies, Chairperson. Chairperson, so thank you very much, Chairperson. I'll be brief. Thank you for the responses. The concern that I had, Chairperson, is that the response from the department basically says that private entities can engage with the regulator, and if the regulator, my question simply is, the regulator can get involved when there is a monopoly of more than 70%, and I'm glad that you raised SANRAL, because SANRAL has a monopoly pretty much on toll roads. And so they can get involved there. They can make a finding that toll fees are too expensive, and that becomes the rule. And then for me, the very interesting situation is that if SANRAL, and this is just an example, have a problem with that, they have to appeal back to the same regulator and not some other independent body. And then the argument could come, well, they can talk to the minister, but the minister instructs the regulator, so they're probably on the same page. So what relief is there to an entity that has a problem with what the regulator has decided outside of the regulator? That's the problem. That essentially is the problem I see. In our courts, you can go up to the Constitutional Court eventually if you still have a problem. But you don't get sent back to the same court to argue the same matter in front of the same judge. And that, for me, is what's happening here. The regulator may make a call, that call may be wrong, and then what does that party do? The aggrieved party, what do they do other than appealing back to the same person or the same regulator that is given the decision that's in dispute? So if I could just get a response on that. It just seems to me that circle isn't closed there. Thank you, Chair.
Thank you, Honorable Brother, Mr. Chikami.
Thank you, Honorable Chair, and thank you, Honorable Brother. Okay, basically, just to provide clarity, is that the bill proposes for the establishment of the Transport Economic Regulator as well as the Transport Economic Council, each established as organs of the state, responsible to the minister. But however, how the two institutions will then function is that there are two separate entities. It's not one individual entities. I'm sure there was a confusion when I was referring to the options which the department opted for in developing the model. The model which we took is the one where you have two separate entities, which is the Transport Economic Regulator, which is responsible for technical, administrative, and enforcement regulator, responsible for carrying out economic regulation, education, research, price control approvals, access approvals, conducting investigations of complaints, enforcement and enforcement of the Act. But however, when you then look at what the Transport Economic Council is, instead of going, if when one is aggrieved to go directly to our court systems, one will then have to go and appeal the decision that has been made by the regulator to what we call the Transport Economic Council, which will be the primary adjudicative entity which is responsible for reviewing the decisions of the regulator. So those two entities, they are separate entities. We are establishing the Transport Economic Regulator. Then on the other side, we are establishing the appeals mechanism, which is the Transport Economic Council. Then should one be aggrieved by the decision that has been taken by or that has been made by the council, that's where one needs to then refer the matter to the judiciary system. I think I've clarified on this matter, Honorable Chair. Thank you.
Thank you, Mr. Chigambi. Very clear in terms of the two separate entities. Is the state law advisor willing to come in now? The floor is yours. I guess there is a challenge in relation to connectivity, but I think from where I stand as the chair, much clarity has been given in terms of inputs made by honorable members in relation to the responses that were given by Mr. Chikambi, and also the broad overview by the legal advisor in terms of what legislation provides around the coordination and interrelations and the interrelatedness about our constitution, particularly in relation to powers and functions. I think there's much more clarity in relation to that. I want to believe that maybe we must just give over to the committee secretary, just in terms of the next process, because definitely just give guidance so that at least we, from here, there is clarity to members in terms of how we move forward. Committee secretary.
Thank you, Chairperson. In terms of the processes moving forward, we have completed, our leg on the public participation. So we are going to combine this leg together with the public participation from the provinces. Remember, Chairperson, the provinces, they are also busy with their, public participation processes. So in November, we are going to be dealing with the negotiating mandates and the final mandates of all these bills. So that is the process that is going to unfold from here.
Thank you, Committee Secretary, in terms of that clarity. And having said that, I want to believe that let's then take this opportunity to express a word of gratitude to first and foremost our honorable members for their participation, for making this meeting a success, and then the department for their readiness to come and give responses to the issues that were canvassed from the public hearing. But also the legal team from Parliament for also ensuring that we are not found wanting when it comes to the issue of constitutionality. But the team also of the Select Committee, from the content advisor to the committee secretary, and the research team, and the support from the assistant committee secretary for their diligence thus far, such that we are then able to ensure that we are moving into the next leg. As correctly pointed out, that will be around November, and then we'll then be able to convene. But indeed, a word of gratitude to all of you for making this meeting a success, also including the parliamentary communication team and also the PMG and our guests. Thank you for honoring our appointment, and therefore the other parts of the meeting. We have 2 outstanding minutes. Let's deal with them in November, because next week we'll be meeting. It will be on the expropriation bill hearing. Let's then meet and then see how do we deal with those outstanding items. The meeting stands adjourned. Thank you.
Thanks, Honorable Chair, honorable members.
Recording stopped.
Thank you.
Thank you, Honorable Chair.
Thank you, Mr. Chikambi.